counsel ready?
Yes, sir. Is the court ready?
Yes, sir. Next case is ANSELMO versus KELSEY, FORREST et al.
May it please the court, I'm Ted Caratinos, and I represent the appellants Henry and Jessica ANSELMO.
Do you wish to reserve any time, sir?
I'd like to reserve 5 minutes for rebuttal, Your Honor.
All right, sir.
We're here on a de novo review of an injunction to remove a family's homestead. The case turns on a deed covenant. The deed covenant says, quote, "No structures may be erected thereon except single-family conventional homes." We ask you to reverse for 2 reasons. The first reason involves an interpretation, a legal interpretation, of the word covenant as it modifies the word home. In weighing a deed covenant, the trial court put its thumb on the wrong side of the scale here. We argue that the term conventional is vague. It's vague, it's opaque. Just as in this court's case in James, where the court interpreted what a domestic pet was in a deed covenant, we look here to what a conventional home is, and we ask ourselves rhetorical questions. What's a conventional haircut? What's conventional dress? Were conventional buildings...
Maybe you can help me out here. I have never heard the term conventional home used in any other context except to describe conventional construction, which would be something other than a mobile manufactured home or trailer. So have you heard it in other contexts? Maybe by reminding me, I mean, it's a common vernacular. I don't know how else you could use conventional home to mean anything other than conventionally constructed.
Well, that's an interesting point, Judge, but again, you're relying on vernacular. And we have a strict construction rule in this DCA that the words must be strictly construed, and the word term conventional is not...
Are you saying that they're not to be given their plain and ordinarily understood meaning?
Yes, and I briefed the meaning from the dictionary, Your Honor, and the term conventional does not illuminate as it modifies the term home. Now, if it said conventional construction, which is easily corrected just by changing the noun, then I would agree completely with what Your Honor is saying. When we look at the Supreme Court of Kansas's case, where they go over what a modular home is in detail, they state that it involves a permanent foundation and that it is essentially a great percentage of it is site-built. I mean, we can go back to the Wild West where homes are site-built as log cabins and guys are cutting down trees and that the home is completely site-built. And if we want to say that's conventional construction or a conventional home, that's fine, but it's still vague. We have no idea of knowing whether we're talking about a conventional home as a log cabin, whether we're talking about a conventional home.
Well, let's look at the community. There was testimony about the number of houses in the community, was there not?
Yes, sir.
How many were there?
Well, there were approximately 40 lots, and about 20 of them or so were developed.
How many of them had a monolithic slab?
I believe they all had slabs, Judge, but I don't know if there was any testimony that they were monolithic.
Well, isn't the testimony in the record that the home that was built first, they were told before they started that you can't bring in certain types of construction to this site, and what you're planning to bring in is in violation, we think, of our covenant. Is that in the record?
Yes, sir, but going forward...
And didn't they bring in then a modular home that they constructed on the site in derogation of the information they received, a letter from the lawyer? Is that correct?
You mean my clients brought in a modular home?
Yes.
Yes, sir.
Okay, well, yes, your clients.
Okay.
And weren't they told that that violated what the covenant intended to prevent, and in fact gave them the evidence that the builder that had a mobile home, a prefab home on the site, was told when that goes down, you're going to have to construct a house with a monolithic slab, on-site construction, etc. Where they shared that information?
Yes, but there was a conflict in the testimony on that point, Judge.
All right.
There were some people that told them, no, you don't build this, and there were others, including the state of Florida and the county, that told them it's okay to build this.
The lawyer representing the homeowners association, did that lawyer send confusing information to your clients?
No, sir, but there was no homeowners association.
I apologize. The lawyer who communicated with them on behalf of the covenant agreement and the deed restrictions, did he not share with them that portion of the deed restrictions and the information that I just relayed to you?
Correct, but the point Your Honor made regarding the mobile home,
Yes, sir.
the mobile home was owned by the developer, and the defendant, a defendant at page 38 of the trial transcript admitted that my client's home was not a mobile home. That's a clear admission on the record. And the fact that there was a settlement agreement shows that that was not actually adjudicated by a court. And when the neighbors had the opportunity to correct and clarify this vague language in the deed through a negotiated settlement, they failed to do so. They simply incorporated the earlier deed restriction into the settlement agreement, and there was no illumination as to the vague term conventional. And so we have a situation where my clients do not have a mobile home, so it's not on all fours with the developer's mobile home in there. And when they had an opportunity to fix the covenant, they did not do so in the settlement agreement.
So to you, on-site construction, conventional, means a modular home that can be brought in and put together?
A modular home is partially brought in, Your Honor. The foundation is permanent. It actually is poured in advance. And the foundation contractor testified at trial that he came in and he poured a permanent foundation, and then the rest of the home was brought in. And here we get into that slippery slope of, first of all, the covenant doesn't say on-site. It doesn't say site built. It doesn't even use the word built. It says conventional home.
Let me ask you something. There was testimony from people in the real estate construction business that conventional home in that business means built on site. Now, I know there was testimony from your side that a manufactured home can be as nice or as sufficient quality as an as-built home. But was there any evidence presented from your side that in the in the language of the construction business or the real estate business, that conventional home included manufactured homes?
Well, there was a real estate appraiser that testified that it was essentially, you couldn't tell the difference after it was built.
That was my question. I'm talking about, here we have language in a covenant, and what does that language mean in the business, the real estate business, the construction business? Now, they put on testimony that it meant one thing. Now, I'm asking whether you put on any testimony that it didn't mean that in the business, the construction and real estate business.
The answer to that is no, but that specific question wasn't asked. But there is testimony that...
Well, you can ask that the person called their own witness and ask them the question.
That's true. And I apologize for that, Judge. I wasn't the trial counsel. But the answer to your question is no. There wasn't testimony on our side to that effect, but there was testimony in and around that question, and inferences could be made that it was considered a conventional home. And even though counsel's argument isn't evidence, it was argued in opening and closing. And let me say this, too, Judge. If we have to put opinion evidence on from experts as to what the term conventional means, doesn't that inherently mean that the term is vague? And doesn't that inherently kick in this Court's rule that vagueness means it has to be strictly construed in favor of the landowner, in favor of the free and unrestricted use?
Is your argument undermined by the fact that your client was put on notice before construction was started that what you're attempting to do, we don't think meets the covenant and this specific deed restriction?
No, Judge, because the notice is not fair, because the notice...
Well, the point being, before you start to build, would it be prudent to clarify, if I'm wrong in my thinking as a homeowner, that means on-site with materials, a monolithic slab? Before you build, you might want to get it resolved?
Yes, and he did, and he tried to. He already had, by the time he was noticed, Judge, he already had a mortgage, he already had a construction loan out. He went to the state of Florida.
Let me ask you, I thought that the record reflected that your client was noticed that this was the other homeowner's interpretation or of that covenant before he ever purchased the property.
There was conflicting testimony on that, Judge, and it was very, very unclear as to whether they said that you can't build this specific type of home on there. There was some discussion about it, but the testimony was very
And that was
unclear.
before he purchased the property.
That's right.
And then there was
he did-
then there was a letter from the attorney, correct?
But that was after he had already taken the mortgage out in a construction loan.
Okay. And then at what point did the trial court enter a temporary injunction prohibiting him from constructing that home, which, at what point was that? That was before construction started, correct?
Very, very shortly before construction started, yes, Judge.
But he purchased the manufactured home after he had notice of the objections and notice of the covenant. But I don't
Very
understand.
close call, Judge.
I mean, I understand your first point, but I have a hard time finding that the trial judge's decision was draconian, where someone gets told, you can't build that type of structure in this neighborhood, and then they go and they say, well, too bad, and then they buy a structure, and then the judge enters a temporary injunction, which suggests that they're going to lose, but they can't post a bond, and then they put the home there anyway, and then complain when they're told to leave. I mean, I have a hard time on that draconian, because otherwise you're saying, well, what the judge should have said was, well, you know, even though they were on notice of this dispute, and even though they were aware that this was a possible remedy, you know, gee, they spent so much time and money doing this, I ought to just forget about it. I mean, I don't get the second argument at all.
I understand what you're saying, but if we step back for a second and we say we have a young family, and they buy a plot of land, and they buy a plot of land to build a house on it, and they get conflicting messages, he does some due diligence. He investigates. What does this mean? He calls some neighbors. He talks to the state of Florida. He goes to the county. He wants to build on his land. That's the whole purpose for buying it, is to build a house for his family. He gets conflicting messages, but he's got the state of Florida and the county with him. So he takes a loan out.
I'm sorry, I'm unclear as to what the state of Florida and the county said. Did they give him advice that a manufactured home would not violate this covenant?
They gave him advice that his home would be up to code, and that they considered his home to be conventional, and that he could go forward. And so he did. And
Did he actually address the terms of the covenant with the county and state officials?
And that's not in the record, Judge, but yes, he did.
Well,
It's not in the record.
It's not in the record.
it's not the record, let's not bring it up.
Yes, sir.
Do you agree that because you can build a home that can pass construction code, it may not be appropriate for a particular neighborhood? For example, a gated community may want so many thousand square feet, they may want a cathedral ceiling, they may want X number of dollars spent on landscaping, and you could build a home that does not follow that deed restriction. It could be sturdy, it could pass the hurricane code, the zoning code, but it would not be appropriate for that community.
I totally agree with that, Judge, but
Well, in this case, wasn't your client put on notice before one spade of dirt was changed or turned that that home you're planning to build is not consistent with the agreement you signed when you bought that piece of property?
No, Judge, because he received conflicting messages. He did his due diligence. Otherwise, he has a piece of property on his hand that he can't use with a construction contract for a certain type of loan that he's going to end up breaching if he doesn't go forward.
Is your whole argument that the term is ambiguous and therefore he should be given the ability to stay in the home and not remove it?
Yes, sir.
Who's Mr. Forbes, Scott Forbes, who testified during the trial?
That's the other side's expert.
Didn't he testify that in the industry there's only one term that would apply based on what he looked at in the deed and the covenant?
Yes, he did, Judge, and that's exactly my point. If you have to bring in an expert to interpret the term...
Well, wasn't
then
he
it's
clarifying for the court to educate the court so that the court would know before making a decision?
Yes, but if you have to bring in an expert to define the term,
All right.
you're using the guy as a legal expert.
Well, don't we do that all the time? For instance, you have a contract that says something's to be done in a reasonable time. Well, in some industries or some transactions, reasonable time might be 24 hours, and something else it might be 60 days, and the court hears testimony from experts about what is common in that industry with that clause. I mean, how is that different than this case where a person came in, an expert, and testified, this is what conventional home means in the construction world and in the real estate world, and then the judge doesn't hear anything to the contrary?
I agree that we bring in experts all the time to talk about what reasonable time is under construction contracts, et cetera. But we don't have a legal standard that says strict construction. And if it's vague, the thumb must be put on the scale of the landowner. And when you add that legal context in, it doesn't matter, because the thumb has to be put on this side of the scale, Judge. Thank you.
Morning, Your Honors. May it please court. My name is Darrell Johnston, and I represent the appellees in this appeal. Addressing a couple of things that Mr. Carachinos mentioned, it is unfortunate that conventional homes is not specifically defined in the deed restrictions, but as the court has stated, you give it its plain and ordinary meaning, and there is no interpretation of a structure that is a conventional home that is something different than a stick-built or a site-built home. Quite frankly, if stick-built was put in the deed restrictions, somebody could say, well, it's not made of sticks. Well, quite frankly, that's not what stick-built in the construction industry means. Sure, it has two different meanings, and there are a lot of words that have multiple meanings, but in the context of these particular deed restrictions, the conventional home is a site-built home. It is not a factory-built home. It is supported also by the fact that when these deed restrictions were created in 1996, there was an earlier set, but when these were created in 1996 as a result of the settlement with this particular developer, part of the motivation of it was we want to make sure that everybody understands that this mobile home, this factory-built home that is currently in this property, isn't a part of this subdivision. And so,
But is there any reason for a future property purchaser to look at some settlement from years ago? Isn't it just reasonable to look at what's recorded as a restriction?
I think certainly the deed restriction itself would be the most important thing for them to look at, but in their chain of title, that settlement agreement is going to appear because it affects everything related to that subdivision. So I think they're on notice of it in any event. And that notice thing is another important factor.
Settlement agreement in the public record?
Yes, Your Honor. It's recorded, and it's recorded before the deed restrictions are recorded, but it attaches a draft of those very deed restrictions that were signed and recorded subsequently. It's a part of that whole settlement agreement. But the notice thing is another important factor. The appellants were given verbal notice by at least two property owners that said, no, you can't bring a factory-built home in here. And they go, no, we're bringing a modular. No, you can't do that. But it's built to standards that are as equal or exceeding anything that a site-built home would be. No, you can't do that. Not only did they get that before I sent the letter on behalf of the homeowners, they got my letter. My letter was a month before they closed on the real property. There was no mortgage of record at the time my letter was sent. It was specifically given them to say, hey, here's a good faith request. Let's talk about this. But there was no response back to me from the appellants. There was no response back to anybody that was the author of that letter. What they did is they went to the building department. They asked the Department of Community Affairs and said, hey, is our home equal to...
To be fair, you've got two competing issues here. There's no argument that the home is shoddy or not up to construction code and that it does not meet the existing code for your area. It is. The issue is that it's not what we agreed we would build.
Correct. That is the issue. It's the issue that we gave them notice that this wasn't permitted within the subdivision, that they needed to do something different, and notwithstanding that, they went forward. They went forward after the court determined at the temporary injunction stage that, hey, this is not what was intended for this Flying Z subdivision. You need to do something different. And yet they continued to go forward. And it's, Your Honors, our concern is that it seems like the appellants have just ignored the information that was to them. Even when they applied for their permit within Citrus County's building permit, on the face of it, it says modular manufacturer. There is a different permit that says single family. And so from the get-go, they're on notice, I think, at every stage of the game that this is not a conventional home as determined under these deed restrictions. I think when you look at what the conventional home is and the scope of these, you need to give it a reasonable reading.
Is that based on the testimony of Mr. Forbes and others in the real estate business that stick-built, conventional built has terms of art that mean specific things.
The reason that testimony was elicited at trial was for the purpose of saying, here's what the ordinary meaning in the vernacular is in the construction industry. If there's any confusion about what it's meant, this is what it is. And there wasn't any other testimony that the trial judge could rely upon that said, well, conventional home means something different. And the entire argument from the appellant's side during the trial proceeding is that quality of construction is the same. And we're not going to dispute that the quality of construction is governed by Chapter 553, which also, by the way, makes the distinction between conventional and factory-built homes. But that the quality of construction is not the issue. And quite frankly, the architectural style was never an issue. There's nothing in these deed restrictions that addresses architectural style. And as has been pointed out many times, somebody could go build a 1,200-foot, square, ugly-looking pink house, and there's not going to be anything the Flying Z Acre subdivision folks can do about it. The issue, though, was that they did not want to have factory-built homes within this particular subdivision. The deed restrictions say conventional homes, and we believe that the granting of the injunction was within the trial court's discretion. There's been no showing that that discretion was abused, and we would request that you affirm the judgment. If you do have any other questions, I'd be happy to answer.
Thank you, sir.
First of all, Your Honors, it's not an abuse of discretion standard under the Pelletier case. It's de novo. Just as we interpret a legal term in a contract, a legal term in a covenant is a de novo review. If we do interpret what Mr. Forbes said, conventional to mean site-built, we're inherently conceding that the term is vague and that the judge needs assistance to interpret the term. Not only that, but where do we draw the line on the slippery slope? At least 50 or 60% of this home is site-built. The foundation contractor testified that he came out and poured the slab just as any other foundation contractor would do, and that a good portion of the home was site-built. So if that's the definition of conventional, where do we draw the line? Do we have to go back to the log cabin? None of the other homes in the neighborhood are log cabins. Why should this home be a log cabin?
Well, sir, don't you think that if there was some confusion before you started construction, you might want to clarify the confusion, especially since you're put on notice by the lawyer representing at least one or two of the homeowners that this was not consistent with what the agreement your client signed?
I agree, Judge, and my client attempted to do that. He talked with neighbors, he talked with the state of Florida, he talked with the county, and he did due diligence. By the time he was ready to construct, he had a loan out there on a mortgage. That's undisputed testimony in the record. He had a construction contract that he had signed, and it's unfortunate that there was a temporary injunction right before he began to build, but he would have been financially ruined if he had stopped at that point. So these are very difficult circumstances. They are unfortunate facts from a notice standpoint, but he received conflicting messages, and when he was already financially outlaid as a young head of household, he tried his best, and he figured, well, I'm either going to be financially ruined or I'm going to go forward and see what happens. And when you receive conflicting messages, because the covenant is poorly drafted, as it is here, and you put yourself in that situation where you have a financial bind, really, it's the lesser of several bad scenarios. And so here we are, Judge.
Thank you, sir. Thank you, lawyers. There'll be a short break. There'll be a reception in the lawyers' lounge for those of you who want to join the judges. Thank you. Court stands on recess for 10 minutes.